Okay. Good morning, everyone, or good afternoon, good evening. Good morning, everyone, or good afternoon, good evening, depending on where you are located. Thank you all for joining us today. I am Abraham Diaz, one of the partners at Olivares, co-heading the trademark and litigation teams, and I will have the pleasure and honor to moderate in this webinar, which is part of a 3-session series addressing the recent reform to the Mexican federal law for the protection of industrial property. Just to briefly recap the structure of the series, yesterday we held a session on patents and innovation. And for those of you who were not able to attend, we will be sharing a link to the recording so that you can access it at your convenience. And tomorrow we will close the webinar discussing strategic implications with a focus on the pharmaceutical sector. But today we will be discussing this reform with a particular focus on trademark and contentious matters. For this effect, my partners, Alonso Camargo, Victor Ramirez, and Jaime Rodriguez, who also co-head our trademark practice, and Alejandro Luna, who directs our litigation and life sciences groups, will focus on the changes that we believe will have the most practical impact on trademark filing and maintenance, as well as enforcement and litigation strategies. It is worthy to remark that collectively, the partners, all of the partners participating in this session bring decades of experience in trademark prosecution and litigation, which allows us to focus on the practical implications of this reform, which we know is what is valuable for all of you. And to anticipate one conclusion from the outset, it can be said that this reform, as for trademarks and litigation, is not so much about expanding IP rights, but about reshaping how those rights are administered and enforced. This reflects INPI's and Mexican government's broader interest in improving innovation, competitiveness, and economic development, and this towards the renegotiation of the USMCA Free Trade Agreement, as well as to deal with the remarks made by the USTR reports in connection with some weaknesses found in Mexican IP systems. However, before we move into the specific changes in trademarks and enforcement, we thought it would be useful to briefly step back and understand the broader context behind this amendment. In particular, how this reform came about and the legislative process that led to its approval. And for that purpose, I would like to invite first my partner Alejandro Luna, who will walk us through the background of the amendment and its legislative development. This will be a brief overview, but it will provide valuable context for everything we will discuss next. But before passing the mic to Alejandro, I want to stress that you are invited to write any questions that you may have as from this moment in the chat of this webinar, so that at the end of the presentation, we can go through all of them as the time permits. And without further ado, Alejandro, the floor is yours.
Thank you. Many thanks, Abraham, for the kind and nice introduction of this panel today. And as you mentioned, my role on this panel today is to provide a brief overview of the legislative background of this reform to the Mexican IP law. Although I would say the formal legislative process began at the Mexican Senate on September 15, 2025, officially. The first draft of these amendments were announced and distributed more than 1 year earlier. And at that time, the main novelties and the main matters of that call our attention consisted in three new figures mainly. Number one, provisional patent applications. Number two, patent restoration rights. And number three, and the one that caused more debate. It was the potential application of the so-called afirmativa ficta. When the Mexican Patent Office, INPI, the Mexican Institute of Industrial Property, fails to issue a timely decision on patents and trademark applications. I mean, this will have meant that if INPI did not decide on time, the patent or the trademark registration will be considered granted under this afirmativa ficta. The afirmativa ficta is a legal fiction in the Mexican law that applies in some administrative proceedings, but those proceedings that does not require substantive examination to grant exclusive rights, such as a patent or trademark or design registrations. So through different means and associations and different associations, professionals and associates and partners of Olivares, we oppose. We oppose to that inclusion of the afirmativa ficta, as we consider that legal fiction will not help in the particular case of the backlog in patent and trademark applications. On the contrary, this figure could have resulted in a significant number of patents and registrations granted, even in bulk, contrary to the applicable law or in violation of third-party rights, due to the lack of examination. And we will also consider that would violate some international treaties on the matter. So fortunately, the voices of IP professionals and associations made some echo in the lawmaker, and the afirmativa ficta was removed during the discussions in the Mexican Congress. And ultimately, the main amendments of the law are summarized in bullet points in the next two following slides. Do you see the slides?
Yes.
Okay, perfect. So you can see that the main, I would say, amendments were on patents, including these provisional patent applications, retirement of patent rights, a maximum of 1 year time frame for INPI to issue a final decision on patents, utility models, and industrial designs applications, actions to claim ownership of patents. There were few amendments for enforcement that they are going to be addressed by my partners later on, and also for distinctive designs and general provisions, other provisions. In those other provisions, we have the creation of a proceeding to obtain a binding resolution in cases of administrative silence of the Mexican Patent Office, especially for trademark and patent applications, so through a specialized technical committee. And this figure and this special technical committee was in exchange of the afirmativa ficta. I mean, you can realize from the entire amendments or this reform, I would say that there are three main topics or three main, I would say, pillars of the reform that can be summarized in number one, the incorporation of inclusive language through the entire wording of the IP law, the granting of additional and stronger powers to the Mexican Patent Office, no? To act as a mediator, arbitrator, and to have some intervention in the transfers of technology and others. Number three, I would say that to try to harmonize the law for the online or digital scenario. Number four, very clear intent to shorten the time frames from for granting patents and trademarks, and that will impact the practice. And I believe that my partner is going to address the impacts in the day-to-day about these max terms to granting especially trademark registrations. And also a very strong focus on patents. Very heavily, this reform has an impact in patent prosecution mainly. And very few amendments for contentions and litigations and trademarks. These reforms did not came alone or in isolation, as they are expected to serve as a negotiation instrument in context of the review of the USMCA, the treaty between the United States, Mexico, and Canada. Personally, I don't believe that this reform is a USMCA reform, and we are going to, in details, especially tomorrow, for the reasons that we do not consider that the reform itself is a USMCA reform. The law, when it was enacted, indeed, it was a USMCA law, but not the amendments. The amendment, I believe, that is a Mexican agenda for IP, no? And we are also currently waiting for the formal publication of the corresponding implementation of the regulations of the law, which certainly will clarify several of the new legal figures, as well as the interpretation and applicability, no? Overall, these reforms reflect a clear legislative intent to modernize Mexico's industrial property system, improving mainly the procedural efficiency. However, the ultimate impact remains uncertain, and from my point of view, it will depend on its implementation, issuance of these secondary regulations, and mainly the ability of the institution and human resources before the Mexican Patent Office. And only time will tell about the success of this reform. And with this, I finalize my presentation, and thank you, Abraham, thank you all, thank you, my partners.
No, thank you, Alejandro. That context is very helpful to understand not only what changed, but also why these changes were introduced. And before we move into trademarks, it really caught my attention, the new powers that you mentioned about INPI, this expanded institutional role of this authority. And this reform, in my opinion, clearly expands INPI powers in a broader and more structural way, not only in contentious matter, but in its overall institutional role. If we look at this amendment, what we see is a clear intention to position INPI not only as an authority, but as an active participant in innovation, technology transfer, and compliance. We have heard President Sheinbaum mentioning so many times the relevance of innovation for her administration. For example, I see that INPI is now expressly empowered to promote technology transfer through contests, awards, and industry initiatives, to provide legal advisory services in connection with licensing, with assignments and technology transfer agreements, and even perform evaluation and valuation of intangible assets. In addition, I also see that INPI will play a more active role in coordinating with other public and private institutions, including the design of incentive programs to promote innovation and industrial property protection. And importantly, the reform also is giving INPI a role in promoting compliance systems within the private sector through training, awareness, and capacity building programs. So this is not just expansion of power, it is, in my opinion, a redefinition of INPI's function within the ecosystem. And INPI is no longer just regulating the system, but it is expected to actively shape it. And from a practical standpoint, this may create new opportunities for companies, particularly in areas such as technology transfer and valuation. But as you mentioned, raises question about institutional capacity and implementation. But this broader role helps explain the direction we will now see in trademark protection. And with that in mind, let us please turn now to see how these changes translate into trademark practice. And for that effect, I will now pass the floor to my partners, Alonso Camargo and Victor Ramirez, who will walk us through the most relevant changes in connection with trademark filing and prosecution. Alonso, Victor, the floor is yours.
Thank you, Abraham. Well, good morning, everyone. Yes, as mentioned already by my partners, Alejandro and Abraham, the most relevant changes in trademark legal framework in Mexico occurred in 2020. Actually, these last amendments published on April 4th are just an attempt to harmonize some concepts that are recognized in the global practice in order to harmonize the protectable assets regulated by our law with respect to those regulated in other jurisdictions. In this regard, as you probably know, three new categories of non-traditional trademark were expressly introduced in these amendments, which are position marks, motion marks, and multimedia marks. These figures were capable for obtaining trademark protection even before these recent amendments, provided that the new definition of trademarks adopted in the Federal Statute for the Protection of Industrial Property in force since November 5th, 2020, substantially changed the subject matter protected as a trademark from visible signs to all signs which can be perceived by the senses, by the human senses. Of course, provided that these are distinctive and capable of being represented in a way that allows a clear and precise determination of the object to be protected. However, the express introduction of these new figures in our law gives, of course, certainty to entities applying for the protection of these figures. Of course, now we shall be attentive to the publication of the new regulations for the Federal Statute for the Protection of Industrial Property, which I understand should clearly establish the specific requirements for applying for protection of these new figures. It is not absolutely necessary because, as you know, from those figures introduced in the law back in 2020, even though the regulations of the new law have been in the pipeline for almost 6 years, this did not prevent the Mexican Trademark Office to grant protection for sound marks or smell marks, even though there were no clear rules to apply for these figures. But hopefully for these new figures, there will be a more clear parameter of requirements to apply for and obtain protection for these marks. On the other hand, there are new grounds for refusal, and I would say the grounds for non-registrability of marks have been adjusted in recent amendments. No? On one hand, the reference to copyright reservation as an impediment to registration was eliminated, while the subject of protection of such copyright reservations remains as an impediment. Titles of periodical publications, names of fictitious characters, and names of artistic groups or individuals remain as an obstacle for registering marks, unless the corresponding rights holders have granted consent. I think this modification is relevant because in the past, as you may recall, sometimes the Trademark Office objected the registration of a mark, asking the applicant to show that they were the owners also of the copyright reservation, while the obtention of this protection is not compulsory, was not compulsory, and is not compulsory. You know? Now, with the way in was this provision was amendment, I think it's clearer and also provides more certainty to trademark owners when receiving an objection from the Mexican Trademark Office. Mm-hmm. The other big change in the absolute and relative grounds for refusal established in our law refers to the protection of elements linked to cultural heritage, traditional knowledge, and cultural expressions of indigenous and Afro-Mexican communities. Prior to these amendments, the above rights were certainly protected through the federal law, which is the federal law for the protection of cultural heritage and indigenous and Afro-Mexican peoples and communities. However, the incorporation of this protection as a ground for refusal in our industrial property law with no doubt represents an improvement to the effective protection of such rights. It is interesting to note that while these grounds for refusal are usually considered as relative grounds, which can be overcome by obtaining the consent of the groups involved, in this case, such ground for refusal remains as an absolute ground for refusal, being consistent with the aim of protecting these assets. In other words, no exception to overcome this specific impediment through a letter of consent was provided. The justification for protecting cultural heritage, traditional cultural knowledge and expressions, and their associated manifestations, as well as the collective intellectual property of indigenous and Afro-Mexican peoples and communities, stems from the need to preserve their identity, dignity, and historical legacy. Safeguarding these elements ensures that unique traditions, languages, and practices are not lost to time or exploitation, and it supports the rights of communities to control and benefit from their cultural assets. Additionally, protection helps to prevent misappropriation, fosters respect for cultural diversity, and promotes social justice by recognizing the contribution of an inherent value of these groups in society. The most important challenge, in my opinion, in this case, will be for the authority in which we will represent the hard work that it is foreseen in training the examiners in order to identify the traditional knowledge that is aimed to be protected and correctly issue their objections duly grounded and motivated. Basically, I think that the above changes are the most relevant improvements of these amendments in terms of subjective rights, and I will share now the floor to my partner Victor Ramirez, who will talk about some other important changes in connection with trademark protection.
Thank you, Alonso. Just before going to Victor, Jaime, since you are more involved into copyright and this sort of cultural heritage rights, is there anything else that you would like to add or remark in connection with these new causes of prohibitions?
Yes, thank you very much, Abraham. I would just like to add some particular issues. I fully and completely agree with Alonso's arguments in connection with these new prohibitions to register trademarks in the Mexican legal framework. And But in connection with this provision related to cultural heritage, I would like to point out that, of course, this inclusion in the Federal Law for the Protection of Industrial Property is a clear consequence of the already existing provisions for sanctioning the appropriation of cultural heritage. And of course, considering that if the use is sanctioned, it is logical that a trademark registration cannot be granted in connection with these legal provisions. So that would be the first point. And of course, it is positive and it is logic that the Mexican legal framework is adapted in these two ways, regarding use and regarding registration. A particular comment that I would like to expose is that from my perspective, the way in which this trademark registration prohibition is a little bit, or not little, not a little bit, is quite broad from my perspective, because it is not restricted or limited to identical or confusingly similar trademarks to elements of cultural heritage, but it is extended also to elements linked to cultural heritage, manifestations linked to cultural heritage, traditional knowledge, and traditional expressions. And from my particular perspective, it is quite difficult to identify which are these elements, those elements, the manifestations and the elements linked to cultural heritage. And that constitutes a challenge for the Mexican Patent and Trademark Office while applying this trademark registration prohibition, because there are also some specific issues which are not entirely clear. For example, it is not easy to identify the communities owning these rights, this type of rights. Accordingly, the Mexican Patent and Trademark Office would face some difficulties in order to implement this trademark registration prohibition. The registration by INPI with N and not with M, that means the Indigenous Institute in Mexico, administers a registry for all these elements of cultural heritage pertaining to indigenous communities. But this registration is not constitutive of rights, but only declarative. And it is the case that not every community in Mexico register those elements which are being considered as part of cultural heritage. Thus, it could be the case that even though if these elements are not contained in this registry, they are protected because, as I was mentioning, this registry is declarative and not constitutive of rights. And it would be difficult to identify these particular elements. And another specific question is that, because I believe that the project of the regulations for the new law will allow the possibility for including the possibility of overcoming this particular trademark registration prohibition through a consent. However, what about the fact that the consent is granted only by one of the communities owning an element of cultural heritage, but it is the case that there is also another community that owns exclusive rights also in connection with the same elements. So INPI will have to face particular issues that are difficult to determine in this moment how they will come out, but this is relevant. And in connection with the prohibition regarding to reservas de derechos, I would add that reservas de derechos is a unique and sui generis particular legal figure only existing in Mexico, tending to protect titles regarding periodical diffusions, artistic names, denominations of artistic groups, characters, and also a specific type of promotions, right? So
advertising promotion, yes.
Yeah. And it is my opinion that there has not been consistency regarding congressmen in Mexico through the years, because they have modified this trademark registration prohibition several times. Actually, this new version of the prohibition is quite similar to the way that it was written before the amendments to the Mexican Industrial Property Law in 2018. And I fully agree with Alonso in the sense that it seems that the congressman was to indicate that it is not necessary that the titles and artistic names and all the legal figures protected by Reserva de Derechos are actually protected by a Reserva de Derechos issued by Indautor, the Mexican Copyright Office, and that Reserva de Derechos is valid. From my particular perspective, it is questionable that a trademark registration should be prohibited on grounds on this particular figure that it is already granted and protected by another law in Mexico, which is the federal copyright law. That will be my comments, Abraham.
Thank you very much, Jaime. Very valuable insights, and I fully agree with you. There has always been a clash between reservas and trademarks, and now releasing the need of demonstrating that you are the holder of a reserva in order to oppose a trademark may cause problems, and also very valuable all what you mentioned as to the problems that there will be with training and interpretation of this new provision in connection with cultural heritage, and certainly it will trigger litigation and a lot of assessment work there with these provisions.
And now, if you allow me, Abraham, just yes? One additional comment, which would be that addresses to our clients that every time you are attempting to use an element that might be linked or considered as part of cultural heritage of Mexican or indigenous communities or Afro-Mexican communities in Mexico, you will have to take care in the advertisement you are intending to promote.
Yes.
And of course, if you are applying for a trademark registration, you should be aware of this new prohibition included in the law.
Yes. Thank you, Jaime. Victor, now we come to you.
Thank you, Abraham. Hello, everyone, and thank you for being here. Well, my partners have already mentioned that these changes to the amendments to the IP law seeks to modernize the legal framework, and it do it by simplifying the proceedings, reducing the time frames for these proceedings, and also strengthening the protection of the rights. So turning to the prosecution of trademark, slogan, and commercial names, how does it impact these changes to the previous status of the IP law? Well, from our analysis, we have detected what we would say 3 principal changes, or the most relevant at least. The first one has to do with the inclusion of faster proceedings of registrations, but also oppositions. Also, the inclusion of a strategic suspension of the prosecution of the trademarks, and finally, the inclusion of a new proceeding to address the trademark office delays. So that would be the three main changes that these amendments include and are related to prosecution. Regarding to the faster proceedings, well, it's very interesting because for the basically for the first time they are including in the law a specific time frames for the authority, basically the trademark office or the trademark officers, to respond or resolve the proceedings and petitions. Previously, usually applicants and users of the IP systems in Mexico are the ones that have the deadline to meet always. But now, in this attempt to be more efficient, they have included these statutory time limits for the authority to resolve an application. These specific timeframes have been included for trademark applications, the resolution of opposition proceedings, renewals, and recordal of trademark licenses and franchises. For instance, in the case of trademark applications, now the examiner has a 5-month term to resolve or an application and grant a registration if no office action was issued, or the 5 months will start running as from the response of the office action by the applicant or response to the position by the applicant. Also, in the case of oppositions, now the examiners have also 5 months to resolve an opposition, and this is also very important because sometimes opposition was some of the main reason for the prosecution of a trademark to be delayed for quite long, beyond 1 year. So now this would be, or we expect to be, a solution for that situation. It's also important to mention that now according to the new faculties that and empowerment of the trademark office, they are now empowered to correct certain clerical mistakes in the applications. Abraham was already mentioned that he sees a shift in the role of the Mexican Trademark Office in the whole ecosystem of IP in Mexico. And I think this is one of the clear examples of how now the administration is seeking for the trademark office to play a different role, where he becomes more active, to say, and now he can correct these clerical mistakes that they may find or detect in the applications, as long as, let's say, the limit is that they cannot alter the description of the trademark or the trademark itself, nor the classification of products or services proposed by the applicant. So, but we think this is going to be a very useful and we think it's a very practical approach to avoid these unnecessary office actions for the applicant to clarify or correct some clerical mistakes that could have been resolved by the examiner. So with these new faculties, the examiners will be able to continue with the prosecution of a trademark application, even if they find this kind of mistakes. And now, the second big change that we have previously mentioned, that is the strategic suspension of applications, refers to a new ground that has been included in the amendments that allows an applicant to ask or request the trademark office to suspend the prosecution of the application if a trademark that has been cited as obstacle, as reference to the application, is involved in a litigation, has been challenged. It can be by nullity, cancellation, on non-use basis, revocation, etc. So, but the change is now that previously that petition for asking for the suspension of the prosecution could be filed only by the applicant that would be the one that challenged the trademark reference. Now, the owner of any application that is facing an objection or an office action on the grounds of a registration that is being challenged by a third party, this means that even if it has been challenged not by the applicant itself, are allowed to ask for this suspension of the prosecution. And it's also important to keep in mind that now the trademark office can also suspend the prosecution of an application ex officio, even without any of the parties asking for it. Okay, so now finally, and this is also we think a good solution, and Alejandro Luna has already referred to this amendment, is the inclusion of a new proceeding to address delays of the trademark office. This was, as Alejandro mentioned, an alternative solution that the administration considered to make sure that the new statutory limits included in these amendments are going to be met, because the challenge is that the trademark office is able to keep up with the pace that the applicants will certainly have by filing applications, petitions, and be able to keep that pace. And
sorry, Victor, 1 minute.
Sure, and to meet the new specific specific time limits. And this decision, this special proceeding, is prosecuted before the so-called special technical committee that can demand to the officer in charge an immediate ruling within 10 working days. And I think that would be all from my side.
Thank you very much, Victor, Alonso, also Jaime. The explanation clearly shows how the scope of trademark protection is evolving, and there are a lot of questions, a lot of things to discuss over there, but time is a cruel master, and now we have to turn to the second part of the session dealing with contentious matters and enforcement. So perhaps when we are analyzing Q&As, we can go back to some of the items that you have mentioned. Now, if we walk through the changes introduced by the reform in connection with enforcement, the first thing that we will notice is various articles that this reform also reinforces the digitalization of some IP proceedings in Mexico. And now this amendment, once again, grants SIMPI faculties to establish rules for the management of proceedings, including administrative infringement proceedings, through electronic communication means. Jaime, could you please tell us more about this change in infringement proceedings and digitalization?
Yes, of course. Thank you, Abraham. Indeed, in these amendments to the law, it is worth mentioning or pointing out that the law only sets or settles the basis for prosecuting infringement proceedings online. But the rules of the proceedings will be not modified and should have been prosecuted as in the terms that it is provided for traditional infringement actions currently in this law. And in any case, I think that the benefit of this possibility of prosecuting online infringement proceedings is that it would be convenient for all parties in the proceeding to make this proceeding more expedite in some cases, in the sense that you will not have to comply with several formalities because it will be possible to file documents through advanced electronic signature having the same effects than original documents. I think that this is the only benefit that the new law provides, what I think is positive. But it is important to make this statement in the sense that the procedural terms will not be modified, and all the rules regarding the filing of electronic documents must be considered and attended by the regulations to the Federal Law for the Protection of Industrial Property, but no provision contained in the regulations could go beyond the provisions contained in the law. So it is clear that the only benefit, as I was pointing out, is that it will be possible to file electronic documents before the Mexican Patent and Trademark Office and to prosecute the proceeding online. It is relevant to point out that this new possibility, it is only provided for infringing proceedings, but not in connection with invalidity actions, non-use cancellation actions, or cancellation actions.
Attention.
Yeah, exactly. I believe that is the main important thing about online prosecution regarding this amendment in the law, Abraham.
Thank you very much, Jaime. So in theory, these changes should streamline proceedings, reduce delays, and increase efficiency. And that's what we are seeing throughout all this reform. We see that yesterday with patents, once again, getting more expedite proceedings. Once again, as Victor explained, with trademarks, expedite proceedings. However, I believe that experience suggests that the challenge is not only legal, but it's also operational. We have seen similar initiatives of electronic filings. For example, the online litigation system before the Federal Court for Administrative Affairs that has existed there in the law for quite some years, but in practice, it never really worked as expected. So there is an operational challenge over there. So it is clear that digitalization is not achieved by enabling a platform. It requires infrastructure, training, and institutional readiness. And I believe this reform points in the right direction, but the real question is whether the system is ready to support it. But we will learn more about this in the near future, as you mentioned, Jaime. Now, let us focus on what is probably the most visible change introduced by this reform regarding enforcement of IP rights, which is ambush marketing. This concept did not expressly exist under Mexican law until now, and that alone tells a lot about why this reform was enacted at this specific moment. Also, all what Alejandro mentioned in connection with the renegotiation of the USMCA agreement. But there is also this particular aspect that to such a degree has caused that some practitioners refer to this law or to this amendment as the FIFA law. The timing seems not to be coincidental with the 2026 World Cup taking place in Mexico, USA, and Canada. It seems that the legislator intended to provide stronger tools to protect the commercial ecosystem surrounding this event. And now, once again, I go back to you, Jaime. Can you please give us some background as to how Mexican IP system has dealt in the past with ambush marketing and explain the change introduced by the reform?
Yes, thank you very much, Abraham. Well, first of all, I think that it will be important to explain the concept of ambush marketing for those who are not related to it. Ambush marketing has been traditionally explained as a strategic, often creative tactic where a brand associates itself with a major event like the Olympics or World Cup to gain recognition without paying official sponsorship fees, right? From my perspective, it is positive that now ambush marketing is expressly regulated, and certainly I believe that it will be a correct tool to combat misleading acts during the World Cup in Mexico, right? However, as Abraham was mentioning, I think that this is not a new topic under the Mexican legal framework, because in the past, it was possible to initiate actions and combat ambush marketing through filing infringement actions using as a basis the generic clauses of fair competition contained in Section 1 of the Catalog of Infringement Actions in the Federal Law for the Protection of Industrial Property. In this new amendment, it calls my attention that in this new amendment, ambush marketing is sanctioned as a specific additional case of infringement by misleading acts against consumers. Specifically, it was added as an additional cause of infringement in Section 2 of the catalog of these infringement actions in Mexico. And properly as a specific action combating misleading acts against improperly suggesting consumers the existence of an official sponsorship relationship between a distinctive sign and a public or private mass gathering event, of course, in Mexico, right? Because this will have to be implemented in Mexico. However, from my perspective, ambush marketing should not only be sanctioned as a misleading act against consumers, but also as an illegal activity against direct or indirect competitors in the market and against the correct functioning in the market per se as such. Sanctioning, for example, taking improper advantage of the reputation of third parties, not only, I repeat, not only by misleading consumers, or by the misappropriation of consumers in the market, that is, desvío de clientela. And I think that a relevant aspect to consider is that sanctioning ambush marketing as part of this Section 2 of the Catalog of Infringement contained in the law might open the door to argue that ambush marketing should not be considered as a specific act of unfair competition, although such cause of infringement has been traditionally considered as such by case law and doctrine. Because if it is implemented, this grammatical interpretation and legality principle operating in administrative law, it could be argued that if the cause of infringement does not expressly state that it is a cause of a specific cause of unfair competition, it will be possible to sanction unfair competition acts without the need of meet the requirement that the parties are actual competitors in the market.
Okay.
INPI's current criterion is to consider that to sanction unfair competition acts is necessary to credit that the parties are actual competitors in the market. Thus, if ambush marketing does not constitute a specific case of unfair competition, it might be possible to sustain that the infringement action could be brought by any interested party and not necessarily by the organizing entity or official sponsors, such as third parties users of pass-along rights, right? And I think this is quite interesting, and it will be convenient to monitor and being aware of how INPI would start to deal with these ambush marketing actions. But of course, the message to our clients is that this is not a new message, because I insist in the past it was possible to sanction these activities through the general clause of unfair competition. But our clients need to be careful with their advertising and need to take proper measures to avoid falling in improper conducts associated to this ambush marketing, right?
Of course.
Abraham, I can see that you are showing some.
Yes, I fully agree with you. It will be very interesting to see in the near future to learn how INPI and the courts will interpret these concepts of official sponsorship, public and private mass attendance event, or to assess the relationship between a distinctive sign and said event. But I want quickly, and we are running against time, but I wanted quickly to bring 3 case studies based on real recent advertisement that I found here in Mexico City, there in the traffic jams that we have. And I believe that clearly illustrating the sort of topics that we are discussing in connection with ambush marketing. First, Jaime, we have this advertisement that I found, as you may see. This campaign is not using the name of FIFA, but it includes Mexico 2026 with the stylization similar used for the World Cup of Mexico 1986, a trophy-like image, and a national team aesthetic. So what's your take on this sort of advertisement?
I think that this is a good example of a case in which the chances that the Mexican Patent and Trademark Office could consider that there is actually an ambush marketing activity, because in this case, it is clear that there is an association, a clear association to the World Cup, using this character with the uniform of the Mexican soccer team, also sustaining the World Cup, using the terms Mexico 2026. I believe that those are elements which are clearly addressing to make reference to the World Cup in Mexico. So
fully agree with you. Second example quickly. Here, the second example is also interesting. The campaign states official sponsor of player number 12 with the fandom. What's your take on this, Jaime?
I think that this, it is not as clear as the first example. However, I see some reference that might lead INPI to consider that there is ambush marketing, but also I believe that there are elements to sustain that there is not a clear reference to the World Cup. It is mentioning the term official sponsorship, from my perspective, is risky, but I only see a green T-shirt, which is not particularly similar to the one used by the Mexican soccer team. And I believe that there would be elements to sustain that there is no infringement action.
I agree with you. I want to see what INPI thinks about this using of the official sponsor, but let's see what comes. And here is On the opposite, I believe that this is something well done. In this case, brands like Nesquik are using soccer as a general theme, focusing on everyday consumption, experience of enjoying the game. It doesn't seem to be associating with the event, but what's your opinion, Jaime?
Yes, I fully agree with you, Abraham. I don't see any particular element making reference to an IP right owned by FIFA. I believe that the rabbit, the uniform of the rabbit, does not make reference to any particular team, but in connection to the traditional colors of this particular brand.
Correct.
And only making reference to soccer, I believe that it is not enough in order to conclude that there is an infringement action in connection with ambush marketing.
Fully agree with you, Jaime. So that was quickly some examples to illustrate what we are talking about. Now, we are really running out of time. So turning to the final item of this presentation, another development introduced by the amendment is explicit recognition of infringement carried out through artificial intelligence. To properly understand this change, it is helpful to quickly look at the reasoning behind it. And I see that the legislative record makes it clear that this provision is not merely technical. It's a response to a very concrete risk that supposedly Mexican government is detecting. And this amendment identifies several types of conduct that are becoming increasingly relevant in the context of AI, such as the generation of misleading or deceptive content, the unauthorized replication of intellectual property assets, the manipulation of commercial or legal evidence, and the improper use of confidential information or trade secrets to train AI models for commercial purposes. So artificial intelligence is not creating new types of infringement, it's only accelerating and scaling existing ones. And in order to deal with these new sort of infringements, this amendment introduced the change. And Jaime, if you can just in a minute tell us about this change in connection with AI.
Yes, of course. The main change is that the new law states that all the infringement actions contained in the law could be sanctioned if they are committed through AI. I think it is positive this recognition by the law. However, I think that AI is only a medium for performing infringement activities, and it is not an infringement conduct as such. The infringing conduct results from crediting and showing an unauthorized use in a market, regardless of the medium that it is used. Some people think that including this specific reference for AI in the law is not enough, and they see it as a missed opportunity for regulating AI in the field of industrial property. However, I think that AI should not be overregulated, and its implications should be developed only by case law. Otherwise, I think that legislators, congressmen, would need to expressly anticipate unpredictable and complex situations in the form of a dictionary, which of course is not the purpose of laws in Mexico. In any case, it would be significantly relevant to monitor INPI's eventual rulings, as well as case law in connection with AI, AI in connection with this provision contained in the law.
Thank you very much, Jaime. If none of my partners has any additional quick remark to make, I will very briefly open the floor for a couple of questions that have been posed by the audience in the chat of the webinar, and the rest will be addressed in private. So one has been posted by Alejandra. It is only mentioning Alejandra. It says, is it possible to suspend prosecution of an application if INPI has cited a third-party application that is currently under opposition? The cited mark is not subject to litigation, but is undergoing opposition. Who wants to answer this one?
If may I?
Yes, sure, Vic.
Thanks, Alejandra. Well, That's a good question, and it would have been nice that this possibility had been included in the amendments, but it wasn't. So basically, the option to petition for the suspension of the prosecution of the trademark application, it's available only when the trademark cited is being subject to a litigation, as you mentioned, invalidity, non-use proceedings, etc. So, but the good thing is that the examiner can continue with the opposition proceeding simultaneously to the substantive examination of the trademark. So, and now having in mind that they have a 5-month term, 5 months term to decide on an opposition, we would expect that the opposition wouldn't cause such big delays.
Thank you, Victor. And the
I
final
think
one.
that, if you allow me,
Yeah,
Abraham,
yes, sure.
I think that is a great question. And I believe that there would be basis for, at some point, claiming the unconstitutionality of this provision as it was drafted in the law, because I think that the reasoning behind this provision is to allow that the trademark registration proceeding is suspended because of the existence of a contentious proceeding. And from my perspective, an opposition is a contentious proceeding. So, of course, I believe from my perspective, it would be possible to explore the possibility of exploring this unconstitutionality action.
I fully agree with that. And the final one, from Ana Bueno, have there been any changes to the invalidity actions? I believe this is in connection with the digitalization and what I told you, Jaime. Why do you think the reform only address electronic proceedings for infringement actions, or has there been any other relevant change?
No, there have not been any changes in connection with the online infringement proceeding. I do not see any reason for why it was not allowed the possibility that to start proceedings and prosecute proceedings such as non-use cancellation actions, invalidity actions, and cancellation actions online. I don't see a particular reasons. I understand that infringement actions are the most serious proceedings, but and that there is a necessity to make the proceeding more expedite and without including such formalities. But I believe that this actually is a missed opportunity in order to implement digitalization and online proceedings in connection with other proceedings.
All of them, of course. Well, with that, I want to thank our speakers this morning for their valuable insights. And before we conclude, we want to briefly reiterate the relevance of the regulations for the federal law for the protection of industrial property. As we mentioned, they are about to be approved and published. And in order to ensure that we are discussing with you the final and binding version, we will wait for their official publication. But once the regulations are published, we will be very pleased to organize a new webinar to walk you through their implications in detail, which surely will be very important. And thank you very much for your time and attention. We truly appreciate your participation, and we hope this webinar have proven useful to you. And we will be very happy to address in private any further questions you may have. Thank you and have a great day.
Thank you.